Layla and Marco. Layla, thank you.
Hi, everyone. Thanks for joining. I'll introduce myself for those of you. I recognize some of the names here. Layla Benampour. I am the chair of the Boulder County Bar Association Natural Resources and Environment section. So nice to see everyone today. Thanks for joining. So today we have Marco Simons talking about the climate change lawsuit brought by the City of Boulder, the County of Boulder, and the County of San Miguel. Marco is general counsel at Earth Rights International, which is a non-governmental human rights and environmental organization with offices in 4 countries. Marco oversees Earth Rights' use of legal strategies, including litigation in the United States, to defend the human rights and environment of communities at home and abroad. He has served as counsel on multiple path-breaking cases involving human rights, abuses by major corporations like Chevron, Unocal, Shell, and Newmont Mining. Also oil and environmental pollution by Occidental Petroleum and Union Carbide, and the case JAM versus International Finance Corporation, which resulted in a landmark 2019 US Supreme Court decision holding that international organizations do not have absolute immunity from suit in US courts. Marco is leading the development of Earth Rights legal work around climate accountability and climate justice, including the lawsuit Boulder County versus Suncor. He has also taught college and law school courses on human rights law and has written or co-authored several articles and other publications on corporate accountability. So welcome, Marco. Thanks for joining us. One of the benefits of having these virtual CLEs is being able to have folks from around the country present for our bar association. So Marco is based out of DC. So without further ado, thanks for being here, and we are excited to hear your presentation.
Thank you so much. So as Layla mentioned, I work for an organization called Earth Rights International, and we do a variety of things, but our legal work centers around human rights and environmental abuses by multinational corporations. And so we litigate a number of cases in US courts. Many of those are on behalf of communities in other parts of the world, but we also litigate on behalf of communities in the United States, including communities here in Colorado with this climate litigation. So I'm going to share a presentation that I've put together here so you don't have to look at me for the next hour. So let's get this going. All right. Whenever I have a captive audience discussing the issue of climate change, I like to start out with a few basic facts. I think that the audience in Boulder County is likely generally aware of the science around climate change, and so I'm not going to spend a lot of time on that. But there are a few things that even a lot of people who are pretty well versed in climate change, I find, don't necessarily know, and that's also because I didn't know these things when I first started working in this field. So first of all, on the, let's see, the question of emissions. So most people know about carbon dioxide and its effect on the climate, but the other major greenhouse gas to pay attention to is methane. And that's important in at least a couple of different ways. First of all, methane is tremendously more, has a tremendously greater warming potential than carbon dioxide does, although it has a shorter lifespan in the atmosphere. But it also complicates the potential benefits of hydroelectric power, because dams, especially large dams with large impoundments, especially in the tropics, emit an enormous amount of methane from their reservoirs, because what happens is they flood a lot of organic matter. That organic matter decays, it turns into methane and is released from the reservoir itself. So some studies have suggested that for some dams, their carbon footprint is actually as bad or worse than a coal-fired power plant. The other major contributor in the power sector is, of course, natural gas, which is itself methane. Now, if natural gas is burned, of course, it turns into carbon dioxide, which has less global warming potential. But the devil is in the details here, because if there's substantial what are called fugitive emissions, that is methane escaping from the system anywhere between the actual gas field and the point of it being combusted, the advantages of natural gas as a cleaner fuel than coal are quickly lost. So at around 3%, if 3% of the natural gas is lost to the atmosphere as fugitive emissions, its advantage over coal is lost. So natural gas is not necessarily the fuel that's going to save us either. Now, the good news on this is that there are fuels that are actually much lower carbon, like solar and wind, and the cost curves on these sources of power have been bending substantially. So this is just looking at unsubsidized costs of power. And the cheapest fossil fuel source at the bottom there is a combined cycle gas turbine between $44 and $68 is the levelized cost of energy. Whereas a wind power plant is generally between $28 and $54. And solar is actually cost competitive with fossil fuels these days as well for new installations. So the good news is that we don't actually need fossil fuels to have cost-effective power generation these days. The problem, of course, is that we have a lot of built-in fossil fuel infrastructure already. A couple of other things to note here. I like people to have an understanding of where the emissions are coming from. China is the largest global emitter, but the United States is second at the moment. But basically, China, the United States, and India are half the problem globally. And so if you're not addressing emissions from these countries, you're not addressing fully half the problem. But of course, different countries have different per capita emissions. And if we look at that, so this is a graph that shows on the bottom population, and the height of each bar is equivalent to per capita, so that the total area corresponding to the country is the total emissions. And so you'll see the US on the far left side with very high per capita emissions, although for this year, Canada was actually higher. I think that's switched a little bit. Whereas most European countries are considerably lower, but they're still above the global average. And then, of course, the developing world is well below the global average. I show this in part because there's sometimes been talk in the last few years about how the United States has reduced its carbon emissions more than, say, France and Germany have since the signing of the Paris Accords. And there is some truth to that US emissions have gone down more than other countries. But the reason for that is because we have much farther to go. And countries like Germany and France and the United Kingdom are already well below where the United States is. So I want to get into sort of how this affects Colorado. I probably don't have to tell you most of this, but I do want to play this this short video, if this will work. which is the video that the communities involved in this lawsuit released when the lawsuit was filed. So let me, hopefully this works. Sometimes there are bugs in this system.
Climate changing.
Oh, sorry, not sure what happened there.
Climate change impacts are already happening, and they're only going to get worse. In fact, Colorado is one of the fastest warming states in the nation, which means climate change isn't just about sea level rise. It affects all of us in the middle of the country as well. Here in Boulder County, we're already experiencing trends in rising temperatures, droughts, early spring runoff, and more frequent wildfires.
San Miguel County is a small rural county in southwest Colorado. We've got a population of 8,000. A natural disaster here could wipe out our reserves in a matter of a few days.
Our communities and our taxpayers should not shoulder the cost of climate change alone. These oil companies need to pay their fair share. Rocky Mountain communities like ours are on the front lines. Our fragile mountain and grassland ecosystems are barometers of climate change. Over the next few decades, climate change is going to create profound threats for our local economy, public safety, public health. Experiencing here in Boulder County, we're projected to face even higher temperatures, more droughts, more wildfires, bigger wildfires, more precipitation in the form of rain rather than snow, earlier spring, more intense rain events that can lead to flooding. But this costs money, and we're already paying big costs for climate change.
Hey, Marco, it's kind of hard to hear the video. Are you able to turn up the volume?
Let me try.
The companies that knowingly cause this problem need to pay their fair share in cleaning up the problem. It's not a matter of
Oops. Let's see. I may have turned up the volume, but also messed with, hang on one sec.
Thanks.
future climate impact. Products would harm communities like ours.
Is that better?
Our communities have acted
Still a little quiet. I turned up the volume on my end, but hopefully folks can do the same.
Okay. Well, I can, if the video is not working well, you know, folks can watch it later. I will circulate this presentation, which has the sort of embedded video link in it. But as you can see, and as I'm sure, you know, most if not all of you have actually experienced, climate change is having a significant impact in Colorado and in Boulder County in particular. So Colorado is one of the fastest warming states in the nation. It's already warmed more than 2 degrees Fahrenheit. And there's going, you know, there's a projected increase in heat, significant increase in heat waves, which have all kinds of impacts from public health to ecological impacts. Of course, snow is extremely important in Colorado, both as a source of water, but also for the economy. And as you can see, there's also extremely worrying trends in terms of snowpack throughout Colorado. which again, I'm sure you know better than I do in terms of how these trends are playing out. That video was shot a couple of years ago, and there were predictions that wildfires would continue to increase. Unfortunately, we've seen that in a very tragic way this year, and right now, in fact, in that you've got the East Troublesome Fire, which would be the largest wildfire in Colorado history if the Cameron Peak Fire were not also burning at the same time. And so you've got the two largest fires by far in Colorado history, both burning right now. Part of the reason for this, in addition to the actual just warming trend, is of course the damage to forests that's been caused by mountain pine beetles and other insects, which is also a direct consequence of the warming trends, because with shorter winters and warmer winters, these insects get additional breeding cycles to where they can devastate forest and outpace their natural predators. In fact, one of the reasons that we started working on climate change in Colorado was that, I took a visit to Rocky Mountain National Park several years before we started this work, and the extent of the bark beetle damage was just so clear and so shocking as a direct climate impact. So why, facing all of these impacts, why did these communities, Boulder County, the City of Boulder, and San Miguel County, decide to file suit against these oil companies? So that goes back to essentially a combination of their contributions to the problem, but also what they knew and when they knew it. Way back in 1968, the American Petroleum Institute, which essentially covered all major oil companies, commissioned a report from the Stanford Research Institute regarding atmospheric pollutants, including CO2. And at that point, the report indicated that if we continue on this trend of transforming fossil fuels into carbon dioxide, that significant temperature changes are almost certain to occur. And this was actually a remarkably accurate prediction that that temperature increase would amount to about at least 1 degree Fahrenheit if atmospheric CO2 increased 25%, and it could be 3 times this figure if CO2 levels doubled. So this was over 50 years ago. By 1980, scientists inside API were telling the industry that there is basically no leeway in the time for action, because it will take time to basically change the fuel system. And so the oil company needed to act now if we were going to avoid large climatic effects. And scientist at Exxon, Henry Shaw, gave a similar message, saying that there will be no likely technological fixes, and that if we wait until climate change effects are visible, are discernible, then any action is likely to be too late to be effective. So I'm sure you all know when Exxon back in 1980 sounded the public alarm on climate change, right? Of course, that's not what happened. It took until 1988, with seminal testimony to Congress by Dr. James Hansen, for the problem of climate change to hit the public consciousness. And at that point, it was a significant bipartisan issue. The United States supported the formation of the Intergovernmental Panel on Climate Change in 1988. President George H.W. Bush promised action, and there were bills with bipartisan support in Congress. The oil industry's response to this was not to echo that its own science confirmed this danger, but to form the Global Climate Coalition to oppose the Kyoto Protocol and to emphasize the quote-unquote uncertainty in climate science. API's Global Science Communications team expressly stated that its goal was to get a majority of the public to recognize that significant uncertainties exist in climate science, to defeat the Kyoto Protocol and any further initiatives to thwart climate change. Their internal scientists, again, continued to warn them. A mobile scientist stated that there essentially is no uncertainty and that the contrarian theories to explain warming were not credible. And in fact, the industry itself began making changes to its projects and plans in order to plan for warming, including making adjustments to offshore facilities to plan for sea level rise, and making plans to explore in a warming Arctic, where with less sea ice, there might be greater potential to explore for oil. Yet even after this, their public communications emphasize the opposite, saying that, scientists cannot even predict, whether temperatures will increase, or what role greenhouse gases are playing in warming the planet. As late as 2004, they were placing advertisements, again, emphasizing scientific uncertainties that limit our ability to understand the human role in climate change. Unfortunately, this worked. In 1992, 88% of Americans believed that global warming was a serious problem. By 1997, this number had fallen by more than half. And still, as recently as 2012, only 45% of Americans agreed that scientists believe the Earth is getting warmer because of human activity. This is something that today, not even the oil companies will deny the scientific facts of climate change, but because of the effects of their public denial strategy, a substantial portion of the public is more denialist than the oil companies themselves at this point. So that laid the groundwork for the accountability litigation strategy. So I'm going to give a brief overview of where this litigation stands, and then I'll get into the legal issues, but I'll pause before doing that. So there have been a number of cases, about 18 lawsuits so far, filed in the last several years, primarily under a public nuisance theory against fossil fuel companies. And many of these cases also bring other claims, including private nuisance, negligence, trespass, and products liability. And in form, they're quite similar to lawsuits against the opioid industry, essentially with local governments seeking contributions for their costs that are occasioned by the company's contributions to this crisis. Right now, you've got cases sort of spanning the country, although Colorado remains the only interior state where climate litigation of this kind is ongoing. Every other case is filed in a coastal state to some degree. Most of these cases are filed by cities and counties. 2 have been filed by state governments, the state of Rhode Island, and quite recently the state of Delaware as well. I'm not going to talk much about these cases, but there are also several suits filed not for public nuisance, not for direct climate damages, but basically around consumer protection or investor protection laws. These cases have been, the first 2 cases were filed by New York and Massachusetts, and more recently, a couple months ago, by Minnesota and the District of Columbia. And The New York case did proceed to trial, and a judge found in favor of Exxon in that case, finding that Exxon had not defrauded investors with its climate change practices. But the other cases are not about investor fraud. They're primarily about consumer fraud. None of those cases have proceeded to trial yet, so we'll have to see what happens with them. Let me pause there to see if we have questions about anything before I get more deeply into the legal issues presented in the case. So any questions up to this point on sort of the background and the sort of basic lay of the land in this litigation? Yes, the slideshow will be made available. It'll be circulated after the presentation. All right, so the question is, how did Boulder County approach us, or we them? So as I'm sure many of you can appreciate, I'm not going to get into the specifics of attorney-client conversations, but the case developed over a number of months in repeated conversations between us and Boulder County. And essentially grew out of Boulder County and then San Miguel County and the City of Boulder's desire to essentially to do all that they can to both address climate change, but also to protect their constituents against the rising costs of dealing with climate change. These are all communities that have been proactive in trying to address their own carbon footprint, but there's obviously only so much that they can do. Even if Boulder were to reduce its own contributions to climate change to zero or below zero, they still wouldn't be able to escape the impacts. Right, if there aren't other questions at the moment. Oh, we have one more. Are we zeroing in on emissions from cars or from oil and gas drilling operations, or both? So the case is not directly about emissions from Exxon. It's about Exxon and Suncor's overall production, distribution, marketing, and sales of fossil fuels. So we're not aiming to control emissions with a lawsuit. And it's not about Exxon's direct emissions primarily. It is about Exxon's role in the overall production and sale and marketing of fossil fuels. So it's about Exxon's responsibility for their sort of the downstream ultimate use of all the fossil fuels that they produce, which when used in their intended fashion, foreseeably lead to climate change and its impacts that we now know Exxon knew about as long as 50 years ago. All right, I'll get into a little bit more of that in just a minute here. So in terms of the key legal issues in the case at the moment, we've got the share back up. So the first question that came up in all of these suits, or almost all these suits, is the question of federal jurisdiction versus state jurisdiction. Almost all these cases were filed in state courts, including this one. And almost all of them were immediately removed to federal court as the defendants argued multiple grounds for federal jurisdiction. So far in most of these cases, there have been 4 decisions, but one of them covered 8 suits in California. The plaintiff communities have won remands back to state court. including the 10th Circuit's decision in the Colorado case. And that was one of the materials that I circulated here. However, there's a bit of a wrinkle here, which is that although the defendants argued 6 or 7 different grounds for federal jurisdiction, only one of those has typically been reviewed on appeal. And that ground is the federal officer jurisdiction statute. Now, Exxon is not a federal officer, but the argument they've made is that these lawsuits implicate fossil fuel activities that they've done essentially at the behest of the federal government, such as drilling on the continental shelf, and that brings them under the protection of this federal officer removal statute. The courts have uniformly rejected this argument, but it does raise another argument, which is the actual scope of appellate review. So 3 weeks ago, 4 weeks ago now, the Supreme Court granted certiorari in one of these cases, BP versus Baltimore. And that cert grant was limited to one fairly narrow question, which is the scope of appellate review of these remand decisions. Generally, when a case is removed to federal court and then remanded back to state court, those decisions are usually not appealable at all. The Congress didn't want cases to spend years in the stage of just determining which court has jurisdiction. And so as a general rule, those remands are not appealable. There are some limited exceptions, and one of those exceptions is this federal officer statute, 28 U.S.C. section 1442. Now, the question that's been raised in these appeals, and the question that the court granted certiorari on, is if you have a federal officer argument for removal, and you also have other arguments for removal, does the scope of appellate review extend only to the federal officer argument, or does it also extend to your other grounds for federal jurisdiction? So the key statute is 28 U.S.C. section 1447D, which says that remand orders are ordinarily not reviewable on appeal, except that orders remanding cases that were removed pursuant to section 1442, which is federal officer, or 1443, which is a civil rights removal, are removable by appeal, are reviewable on appeal. So the question there is, when they say a case removed under section 1442, does that mean you get to review all grounds when 1442 was one of the grounds for removal? All of the appellate courts in these cases have said no, have said that you only review the federal officer ground. But there is an outlier 7th Circuit case in a different context that says you review all of the grounds for federal jurisdiction. So that's the issue that is currently before the Supreme Court. The merits of climate litigation are not at issue in that proceeding. However, the effect of this, if the Supreme Court were to reverse and decide that that all of the grounds for removal needed to be addressed on appeal, would be that the appellate courts in these cases would need to go back and review all of the 6 or 7 grounds for federal jurisdiction that the defendants have raised in these cases. But what's currently before the district court in our case, the Boulder County District Court, are a couple of motions to dismiss, including on issues of personal jurisdictions and question of failure to state a claim. So on personal jurisdiction, these cases, including the Colorado case, typically include a combination of both in-state and out-of-state corporate defendants. In our case, we've sued Exxon and Suncor, which are major contributors to climate change, but also major participants in oil and gas activities in Colorado, as well as the in-state subsidiaries of Suncor. As all of you probably know, Suncor has a substantial presence in Colorado, centered around its refinery in Commerce City. But the out-of-state parent companies of Exxon and Suncor are arguing that they're not subject to personal jurisdiction here. And this is a key issue in all of these cases. Now, there's a lot of tricky arguments in this personal jurisdiction space, so I'll go over a couple of them. In our view, the long-standing rule on personal jurisdiction has been that if you harm property in the forum, you are subject to personal jurisdiction there. So if you contribute to a nuisance in Colorado, you're subject to personal jurisdiction in Colorado. The alternative rule would essentially mean that, you know, somebody could cause you harm in your state where you live and harm your property, and yet you'd have to go out of state in order to chase them down to obtain remedies for that harm. We don't think that's ever been the rule, and we don't think it makes sense either. So we essentially think that harm, you know, sort of knowingly, foreseeably causing harm in Colorado and to property in Colorado is enough for personal jurisdiction, and that's been the common law rule for centuries. But that's not all we have here. There are also extensive in-state contacts because both Exxon and Suncor have engaged in fossil fuel production and sales in the state of Colorado. And of course, all of those fossil fuel activities ultimately contribute to the climate change harms that the plaintiffs are complaining of here. Now, the defendants, however, are arguing that essentially the in-state conduct that's attributed to them must be the entire cause of the injuries that the plaintiffs are suffering here. They are ignoring the in-state effects of their conduct as a potential contact with the forum and saying all of the harm must arise out of their in-state activities. And in the climate change context, they argue that because there's multiple contributing factors, this means there can't be personal jurisdiction over them for climate change harms. Essentially, they're arguing that their in-state conduct must be a but-for cause of any claims in order to exercise personal jurisdiction over them, and that that simply can't be the case because there are so many different things that are causing climate change. Our argument is that this is actually not the law. That the law says that all that is required is a substantial connection between the contacts with the forum, and that includes both activities in the state as well as effects in the state and the claims at issue. And even there are some courts that have required this but-for causation. The Colorado Supreme Court has not. But even those courts find that this level of causation is satisfied where any event in the causal chain leading to the injury happened in the state, and we believe that's the case here. However, the Supreme Court has also thrown a bit of a wrench into this as well. So there are a pair of cases known as Ford Motor Company that are currently before the US Supreme Court and were argued on October 7th. As of yesterday morning, the Boulder County versus Suncor climate change litigation has been stayed pending the resolution of the Ford Motor Company cases. And several other cases in Baltimore, Rhode Island, and King County have also been stayed for the same reason. So the issue in Ford Motor Company is whether personal jurisdiction is appropriate, where the forum contacts at issue did not give rise to the claim in any way, i.e. where the plaintiff's injury could have happened in exactly the same way regardless of the forum contacts. In both cases, the issue is that the plaintiffs bought Ford cars used. These cars were sold in other states, and so there was no in-state conduct that actually led by Ford that actually led to the injuries in these cases. However, Ford, of course, also sold cars in these states, just not these particular cars, which were originally sold in other states. So that is the question before the Supreme Court in Ford Motor. We think that whichever way the Supreme Court comes out in Ford Motor, that we have a significantly stronger basis for personal jurisdiction in our case. But at this point, we'll have to wait and see because the case is stayed pending that decision. One additional note on personal jurisdiction, if you may remember from a previous slide, one of the most recent suits that's been filed was by the state of Delaware. And as you may know, Delaware is home to a very high number of major fossil fuel companies who are incorporated in Delaware, even though they might be headquartered elsewhere. And so if personal jurisdiction issues become a barrier to remedies in many of these cases, that is probably not going to be a problem for the Delaware lawsuit. Let me pause here again to see if there are questions or comments about the personal jurisdiction issues at issue in this case.
Marco, I have a question. You had mentioned just now that regardless of the way the Ford Motor Company case turns out, you think there's still strong arguments for personal jurisdiction. Can you explain that a little bit further?
Yeah, absolutely. So the way the Supreme Court formulated the question presented in Ford, it is whether you can have personal jurisdiction where the in-state conduct and the direct forum contacts did not actually contribute to the chain of causation for the injury. In our case, both the in-state conduct and additional forum contacts are quite related and directly in the chain of causation for the injuries here, because all of their fossil fuel conduct, which includes activities in the state of Colorado, it includes directing products through the stream of commerce into Colorado, and again, it includes not just their in-state activities, but it also the in-state effects of their activities, including causing injury in the state of Colorado. So we believe that there's a much stronger connection between their forum contacts in this case and the claims and injuries than in Ford Motor. So question in the comments. somebody who teaches civil procedure, yeah, there's a lot of interesting civil procedure questions coming up in these cases, and I'm sure there will be more. The but-for test comes out of the arising out of element for personal jurisdiction. Don't some states also have an evidence test that is narrower? Some states may, and some federal courts have as well, but my understanding is that Colorado has not imposed a narrower test on this. And Colorado has not imposed a but-for test on the minimum contacts part of specific jurisdiction. So another question in the comments: if the facts of the climate suit benefit the plaintiff no matter what the result of forward, why did the court in the climate case order a stay? That's a good question. We argued against a stay, but I think the judge in this case understandably thought that regardless of whether forward would be dispositive of this case, it may well provide some significant guidance which will help the court decide the personal jurisdiction issues in this case. Again, we thought that we would be able to win the case regardless. We have other theories of personal jurisdiction as well that I didn't get into, but it's entirely possible that the court thought that the Supreme Court could decide Ford Motor in a way that would clarify that personal jurisdiction is absolutely proper in this case, and the district court here would not actually need to get into some of the more contested issues presented by the parties. But we'll have to wait and see. And it's also, I think, the court probably thought that it was a relatively short period of time since Ford Motor had already been argued and submitted by the time the court issued its stay. Who is the judge who stayed the case? That's Judge Labuda, who my understanding is that she has now cycled off the civil case docket, but appears to be still handling this case. But those of you who are local practitioners would know how that works much better than I do. All right. So let me go forward with some of the substantive liability issues in the case. All right. The defendants, of course, have also moved to dismiss for under 12b-5 for failure to state a claim. And their brief made fully 16 different arguments for dismissal. I'm sure they would characterize this as, showing how weak our claims are. I tend to look at this as they couldn't figure out what their strongest arguments were. They made 8 different arguments based on federal doctrines, including the Commerce Clause and the First Amendment. But their lead argument here is that federal law essentially preempts dealing with climate change under Colorado law. Now, this argument is a little bit challenging for them, in my view, because they argue that federal common law applies to climate change because it's an issue of interstate pollution. But they also argue that any federal common law claims have been displaced by the Clean Air Act following the Supreme Court's decision in AEP versus Connecticut. So they're essentially saying that a body of federal common law that has itself been displaced nonetheless preempts the claims, the state law claims here. That would be a very novel application of federal preemption law. They also, however, argue that the Clean Air Act itself also preempts, even though there's a very fairly clear state law savings clause in the Clean Air Act, because they're arguing that although the Clean Air Act does not address these particular claims and does not give a mechanism for individuals or communities to address these nuisance type claims, they argue that it occupies the field. They also make a number of arguments under Colorado law. Here, their lead arguments are based on causation. And this is one of the, I think, more challenging issues to sort of get your head around in climate litigation, just because of the complex nature of the problem. But in our view, when you look at it from a legal perspective, there's really no barrier to liability here. Because although the chain of causation is somewhat long here, it was all entirely foreseeable and intended in the legal sense. And basically what the defendants are arguing here is that no one can be held legally responsible for climate change because lots of people caused it. One of the main counter arguments against that is we're not actually seeking to hold Exxon or Suncor entirely responsible for the costs here. All we are seeking to do here is to hold them responsible for their portion of the climate change harms that was caused by their contributions. And so while that might not be 100%, and it's not 100%, it's also not 0%. And so it should be up to a jury to decide what portion of that responsibility should be borne by these companies. There's no doctrine in the law that if a lot of people cause a problem, nobody is responsible for it. Sometimes I like to compare this to the murder of Julius Caesar, where a number of conspirators got together and they all stabbed him to sort of deflect individual responsibility for his death. But legally speaking, I think they would all be responsible. And in fact, the arguments here are actually stronger, because while in that case, it's hard to say which cause would have been sufficient or necessary to cause the death, which is kind of a singular harm. In this case, every additional contribution to climate change makes the harm worse. And so there's no threshold where we can say, above this level, climate change would have happened, below this level, it wouldn't have happened. And so Exxon's additional contributions didn't matter, or Exxon's contributions weren't enough. Every additional ton of carbon makes the problem worse. And so in that case, it's really impossible to say that they did not cause the harms here. The only question is how much of the harm did they cause? And in fact, that's why the traditional rule in nuisance liability is that all who contribute to the creation of a nuisance are liable for it. Finally, the defendants also make several specific arguments to challenge some of our claims under Colorado law. They make this argument that under nuisance law, the court will need to address sort of the costs and benefits of fossil fuels writ large, that you can't assign liability unless you determine that fossil fuels have no social benefit. We don't think that's what nuisance law means. In our view, the real question under nuisance law is whether it's reasonable, not whether it's reasonable to use fossil fuels, but whether it's reasonable to knowingly cause climate harms through the production, deceptive marketing, and sale of fossil fuels without compensating for those harms. So the question is it reasonable to leave these communities without compensation for these harms and leave the companies with the full profits for them? We're not trying to shut down Exxon or Suncor or stop the production of fossil fuels. And our argument is that this concealment and deception don't have any social benefit, and that's the real issue here. We also brought trespass claims. They challenge those as well because they say they didn't intend the various trespasses that we're alleging here. but we believe the standard under Colorado law is whether they intended the acts that would cause the intrusions onto the plaintiff's property. And those intrusions range from some of the things we talked about earlier. The wildfires, for example, can be considered a trespass. And so, well, regardless of whether Exxon intended that wildfire would affect property in Boulder County, they intended the acts that would lead to that event. Then finally, we're also bringing claims under the Colorado Consumer Protection Act, which is essentially a fraud claim for the deceptive conduct that we talked about earlier. And we're alleging that Colorado consumers were harmed by this. The other issue in the case is proper venue, which is kind of a fun issue, but I don't think we have time to get into it. I'm happy to follow up with anybody who is particularly interested, but I do want to leave a couple minutes at the end here for any last questions.
Marco, once, assuming the case moves forward in some way after the board motor decision, will you be having oral argument on these motions?
So we've already had oral argument on these motions. We argued this at the beginning of June. So it's been under submission for several months now. And I should say that regardless of Ford Motor, the case will move forward because we have 2 in-state defendants for whom personal jurisdiction is not contested. So one way or another, we will get to the 12b-5 motion. But that motion may look a little different depending on which defendants are in the case. So there's been asked for my contact info. I'm happy to have that circulated for anybody who wants to ask any follow-up questions or further discussion. So I think we can circulate that along with this presentation itself, if anybody's interested. If there are no other questions, I will give a very brief let's see, 1 minute on venue, just because I think this is sort of interesting. I'm not going to get into the basic arguments about proper venue, but I will get into a somewhat audacious choice of forum clause that Suncor is making here. So Suncor is arguing that an asphalt supply contract between San Miguel County and Suncor USA ousts venue over the climate change litigation. Their original contract, which is again an asphalt supply contract, states that actions arising out of that contract, arising out of or relating to this agreement, should be litigated in Denver. That agreement then led to a series of annual contract confirmations over price, which didn't include any further terms about choice of forum until after we filed this lawsuit. After we filed the lawsuit, Suncor added additional terms into these annual confirmations where they sneaked in these clauses where they said any and all claims between the parties regarding any and all matters are subject to exclusive jurisdiction in Denver. And then even after that, in 2019, they said any and all claims between the parties and their affiliates trying to get all Suncor entities regarding any and all matters. So essentially they're trying to transform this asphalt supply contract into a general choice of forum clause between San Miguel County and all Suncor entities. I think this is fairly outrageous, and it also raises significant ethical issues because these contracts were sent to non-lawyer employees of San Miguel County. And if any lawyers were involved in drafting these provisions, and I find it hard to believe that they were not, In my view, that's a prohibited ex parte contact between opposing counsel and non-lawyer employees of an opposing party about the subject of the litigation, expressly for the purpose of trying to oust venue in this case. So it doesn't have much to do with the broader issues, but I thought it was a fun little ethical issue to throw in at the end. So with that, we are over time. So thank you all. Again, I'll circulate these slides. My email address is on the last slide here as well, if anybody wants to follow up.
Right. Well, thank you very much, Marco. It was fascinating, and will be interesting to watch how the case progresses.
All right. Thank you all for participating. And I hope the fires come under control very soon. Take care.